My name is Vivian Calder, and before you assume anything, no, I didn't always look this sharp. I used to wear hand-me-down blazers, second-hand shoes, and a nervous smile. The kind of smile people don't notice at family dinners unless you drop a wine glass. But I learned over time that silence could be a sharper blade than sarcasm. My father died on a Thursday. I didn't even get a call. No condolences. No funeral invitation. No courier dropping off dusty heirlooms. Just a passing mention in a Facebook group my cousin forgot to set to private. That was how I learned the man who raised me, who taught me to read by making me study his case files, was gone. And when I asked for a copy of the will, my sister replied with a laughing emoji. Not even a sentence. Just that, a yellow face grinning like a knife. Here's the part where most people cry. I just shut my laptop, walked to the kitchen, poured a glass of Malbec, and opened the drawer where I keep my father's notarized power of attorney. Still valid. Still irrevocable. Still binding. Trust me, you'll regret skipping this part. So before you sit back and listen, take a moment to like the video and subscribe to the channel, but only if you really like what I have to say here. Now get in the mood to listen to this story, because it might be the ultimate sweet revenge. The truth. I had always known this would happen. My family is old money. Not flashy rich, just deeply rooted in the kind of Southern wealth that thinks it's tasteless to talk numbers, but not tasteless to cheat your daughter out of her inheritance. We come from a long line of lawyers, judges, and polished liars. When I left home at 22 to finish law school out of state, I became a shadow in their family album. They said I was too sharp, too opinionated. My sister once told me I cross-examined people at brunch. Maybe. But when you grow up watching legal dramas with your father instead of cartoons, you learn to speak in opening statements. My dad never said it aloud, but I was his mirror. The others were his legacy. He left the firm to my cousin Graham, the beach house to my sister Madeline, the boat to my Uncle Charles. Me. Nothing. At least, not on paper. See, most people don't read wills. They just hire someone like me to interpret them. That was their first mistake. Because I wasn't just reading it, I had written the first draft. 3 years ago, during a family scare when Dad had a minor heart issue, I helped him draft an estate plan. I filed the documents. I notarized them with my then employer. I even reminded him to name an executor. He never changed the executor. That name was mine. Still legally active. They never checked. So while the rest of them were sipping cocktails on the porch of my dead father's beach house, clinking glasses to their imagined victory, I was dialing the courthouse clerk requesting a probate hearing as the listed executor of the estate. And yes, I wore my sharpest black suit. The one with the velvet lapel. Because grief may be messy, but court is not. I remember the first court date vividly. I walked in heels, echoing like gunshots across the marble hallway. My sister was already seated at the far end in a floral dress like she thought we were attending a brunch, not a battle. Graham had his Bluetooth headset in. Uncle Charles smirked at me. I just smiled. Vivian, the judge asked, glancing down at the folder. Are you the petitioner and named executor? Yes, Your Honor, I replied smoothly. I believe the family overlooked that clause. I handed over the power of attorney still active, never revoked. I handed over the original draft of the estate plan with my annotations, with initials Dad had scribbled in his classic crooked scrawl. The air changed. They all shifted. My sister blinked. Graham took off his headset. My uncle's smirk evaporated like cheap cologne. And I just sat there, calm as marble, watching them read the truth written in black ink. The will may have named them the beneficiaries, but the process, the execution, that was me. And suddenly, I wasn't the estranged daughter anymore. I was the storm they forgot to track. They always thought blood would keep me silent, that no matter how far I moved away, no matter how long I stayed quiet, I'd never bite the hand that once packed my school lunches, that somehow being family made them untouchable. But family isn't immunity. And they forgot I was raised by a lawyer who used bedtime stories as mock depositions. Madeline, my older sister, used to be the golden girl. Cheer captain married at 23 to a neurosurgeon named Lucas, the kind of man who drinks orange juice with pulp. She once told me I was too intense to be likable, that I'd never get anywhere if I didn't soften my edges. She was right, edges cut. After that first hearing, she called me. Not to apologize. Not even to fake civility. "You're really going to make this ugly?" she asked. "Not if you read the documents, Mads," I said. "They're actually very elegantly structured." Click. I gave her a day. 1. Then I filed my first motion to freeze all estate asset transfers until formal validation of the will's full chain of custody. Legal speak for nobody touches a damn thing until I'm done counting. They panicked. Graham sent a text. "Come on, Viv. It's not like Dad didn't love you. He just wanted to keep things simple." Yeah, cutting someone out entirely is so simple. I screenshotted the text and added it to my file. I keep receipts. Professionally. Now I should clarify something here. I didn't want their things. I wasn't after the yacht or the antiques or the dusty trust fund. I wanted the principle to stand, because I remembered the last real conversation I had with my father. He was tired that day, sunburned and half dozing on the back patio. "You know," he said, sipping sweet tea, "if I ever disappeared, don't let them bury me twice." I thought it was a joke. It wasn't, so no, I didn't come to play fair. I came to finish what he started. The next few days were a flurry of emails, subpoenas, and quiet strategy. I reviewed the entire probate file. I flagged every inconsistency, dates that didn't match up, a signature that looked suspiciously digital, a missing witness line, and then I found the clause. Buried deep in the appendix of the updated will version C, to be exact, was an exclusion clause. It stated, "All prior versions of this testament are rendered null unless initialed here." There was no initial, which meant the previous version, the one I drafted with him in that cramped home office 3 years ago, was still valid. And in that version, guess who got the firm? The House. The deciding vote on asset division. Me. Of course my family didn't know that yet. I kept that fact pocketed like a dagger. Instead, I played calm, courteous, even sent Madeline a bouquet of white lilies with a note that said, "Thinking of you during this stressful time. Warmly, Vivian." White lilies? Funeral flowers? She got the message. That night, I poured another glass of wine, opened my legal pad, and made a list. A war list. Find the notary who witnessed the last version. Check the bank's safety deposit box access log. Confirm property deed timestamps. Review trust language for successor conditions. This wasn't just revenge. This was reclamation. You can't steal what was already legally mine. You can only delay it. And delays. That's what lawyers bill for. The next court appearance, I brought my briefcase and a smile. The judge addressed me first. "Ms. Calder, you filed a supplemental petition regarding a prior version of the will." "Yes, Your Honor. I believe my late father's last valid testament differs significantly from the one submitted by opposing counsel." Graham whispered something to his attorney. "Probably. What the hell is she talking about?" I stepped forward. "I have the original. Dated, signed, witnessed, and notarized. All legally verifiable. And it names me not only as the executor, but as primary trustee of the estate." The silence was beautiful. I handed over the documents. My sister's mouth dropped slightly open. My uncle rubbed his jaw. The opposing counsel blinked so many times I thought he was trying Morse code. I turned face them fully and said just loud enough for the record to catch it, "You should have called me." They say the devil's in the details. But in probate law, power is in the paperwork. And the devil. She's wearing Louboutin block heels and carrying a leather-bound briefcase. They didn't understand the gravity of what I'd done. Not at first. To them, wills were just dusty documents you skim nod at and then cash in. They thought estate law was for people too boring for litigation and too polite for criminal court. They didn't realize that when it comes to the transfer of generational wealth, the person holding the pen is more dangerous than the one holding the gun. And I held the pen. Let's talk about the clause. The will they submitted, version C, had been signed during a family vacation at Lake Marion. Convenient. Everyone there except me. No neutral witness. No attorney present. No timestamp other than a smudged scan. Suspicious, right? Now in version B, the one I drafted with my father, we'd added a clause requiring any future versions of the will to be witnessed and notarized by 2 non-beneficiaries, one of whom must be legal counsel. That was Dad's paranoia talking. Guess what version C didn't have? Any of that. But I wasn't just going to waltz in and accuse them of fraud. That would have made this messy. I prefer elegance, like a scalpel. So I called the county clerk and requested a verification of document notarization records for the week. Version C was allegedly signed. Nothing. Not one entry under my father's name. Strike one. Then I checked the guest list for the lake house. Graham had bragged about the whole family trip on Instagram. Posted a group photo, tacky polos, red solo cups, and my father sitting off to the side, face half turned. I zoomed in. In his lap, a thick folder with a yellow tab. I recognized it. My version. Strike two. Then I called in a favor. See, my roommate from undergrad now works at a digital forensics firm. I asked her to look at the metadata on the scanned version of version C they had submitted. Edited 3 weeks after Dad's death. Strike three. Game on. I didn't go nuclear right away. No, I filed a quiet motion for a forensic review. No accusations. Just a polite request for chain of custody verification and signature authentication. Their lawyer fought back. Filed a motion to dismiss, argued that I was weaponizing procedural technicalities. I smiled when I read that. That's lawyer speak for she's winning. In the meantime, I did something truly petty. I booked a consultation at Graham's law firm, used a fake name, sat across from him while he pitched his services like I didn't know his entire GPA history. He called me Miss Grant. I leaned in, looked at him and said, "Graham, it's Vivian. You're under review in probate court. I suggest you get a new script." I stood up and walked out. 2 hours later, he texted me. No words. Just a question mark. I didn't respond. That week, the judge granted my request for a stay on all asset distribution until the authentication process completed, which meant no one could sell the house. No one could touch the investment accounts. No one could access the trust. Everything frozen. And the best part, as the named executor in the prior valid version, I now had full legal standing to investigate. I hired an accountant, hired a handwriting analyst, and just for fun, I called in an estate historian who specialized in inheritance disputes. My family didn't know whether to be scared or insulted. I hoped for both. The next hearing was different. The energy had changed. Madeline looked tired. No makeup, hair pinned back like it was a school detention. Graham avoided eye contact. Uncle Charles wasn't there. The judge turned to me. "Ms. Calder, your supplemental evidence has been reviewed. The court finds sufficient cause to question the authenticity of the submitted document." Boom! I sat very still, dignified. Inside, I wanted to laugh like a Bond villain. Therefore, the judge continued, this court will proceed with examination of the previously submitted version B until further notice. Translation: your will is fake. Hers isn't. And just like that, everything began to tilt. I could see it happening in real time, their certainty cracking like a windshield under pressure. They weren't used to losing not like this. Especially not to me, the quiet one, the odd one, the one who always read the fine print while they played croquet on the lawn. But I wasn't the weird one. I was the prepared one. And now I was also the one in control. There's a certain look people get when they realize you've outplayed them using rules they never bothered to learn. It's a mix of confusion, disbelief, and an undercurrent of panic, like watching someone smile while holding the instruction manual to the bomb you just built. That was Madeline's face. After the court reinstated version B of the will, she stopped showing up in pastels. No more floral dresses, no more chirpy voice. She walked into the next hearing in all black heels, too loud face, too tight, as if dressing for a funeral she finally realized was hers. Graham, on the other hand, still thought he had a move left. He sent over a compromise proposal through his lawyer. It read like a bargain from someone who didn't know they were already bankrupt. Mutual asset division to avoid extended litigation. Recognition of emotional strain in family relationships. No public dispute. I filed it directly into the shredder. Then I bought a new shredder just so I could do it again. What they didn't understand was this. It wasn't about the stuff. It was about the truth. And the truth was, I was still power of attorney on several documents they hadn't even considered. Healthcare proxies, medical directive overrides, durable financial control for certain investments still in Dad's private account. You think they'd have asked who closed those accounts after his death? They never did. Meanwhile, I hired a title researcher to look into the family house deed. Turns out the house wasn't even fully in Dad's name. He had transferred 40% ownership to a holding company, one I created. When I was 29, he wanted me to have protection. He knew the rest of them would claw at whatever they could. That 40% gave me leverage. It also meant they couldn't legally sell or rent the house without my consent. And I didn't consent. The panic grew in small, delicious ways. Graham stopped responding to emails. Uncle Charles. Oh, Uncle Charles. He finally called me. First time in 4 years. Vivian, he said, voice gruff. We're family. Let's talk this out over dinner. I paused. You mean like the dinner you all had without me? Right after Dad died. Come on, he sighed. That was a celebration I finished for him. Of a win you didn't earn. Click. My therapist says I need to work on closure. I think that was closure. And then came the mail. A thick padded envelope arrived at my apartment. No return address. Inside, a USB drive. And a letter. In my father's handwriting. Viv. If they're reading this, it means they tried to bury you in the fine print. But I know you better. You'll be standing. I've enclosed the audio from our last revision meeting. Use it if you need to remind them who made this war legal. I sat there, heart thudding, USB trembling in my hand. The audio? Crystal clear, dated 6 months before his death. Him saying I trust Vivian to carry this through. The rest, well, you've seen how they are. It wasn't just a will. It was a blueprint, a confession. And now it was mine. The next court session I submitted it quietly, filed it as supplemental evidence. Didn't even raise my voice. Just handed it over with a label. Testator's intent audio confirmation. They didn't even try to deny it. They looked like fish gasping in air. For the first time, I didn't feel like the outsider. I felt like the architect. Because here's the thing. They never understood about me. I wasn't angry. I was ready. There's a difference. In-court smiles are weapons. The trick is to never be the first to use one. You wait. Let the room tense. Let the air stiffen. Then flash a quiet, brief grin, like you already know how it ends. That's exactly what I did the morning the audio was played. The judge leaned in. The clerk hit play. And my father's voice echoed through the room. Calm, gravelly, unmistakable. Vivian will understand how to handle this. She's methodical. She doesn't get distracted by emotion. I don't trust the others to treat each other fairly, not with money involved. The gasp Madeline let out was chef's kiss. The kind that says, oh God, he really meant it. You could feel the temperature in the room drop 10 degrees. Even Graham, who usually tried to look like he was bored to death, suddenly found great interest in the knot of his tie. The judge nodded slowly, hands steepled. Duly noted for testator's intent, he said, we'll move forward with the presumption that the earlier version was deliberately crafted in alignment with the testator's expressed wishes. Translation. Vivian wins this round. Keep squirming. After that hearing, I walked straight to the parking lot and exhaled for what felt like the first time in weeks. It was raining a soft, misty drizzle, and I just stood there for a moment. Not crying, not laughing, just existing. This wasn't justice. Not entirely. It was strategy. Precision. A reminder that knowing the law isn't the same as knowing how to use it. And I did. Better than any of them. Later that evening, I got a call from a blocked number. I never answer those. But I did this time. Instinct. It was my cousin Elise. We hadn't spoken since I was 25. She whispered, I'm proud of you. I blinked. Sat down. I found the letter he wrote you, she said. I wasn't supposed to see it. But I did. And it was different. The way he wrote about you. Different how? I asked. Like you were the only one who ever listened to him. Not just obeyed. Actually listened. I didn't say anything. She added, you don't owe them anything. Not even forgiveness. Then she hung up. I stared at the phone for a long time. That call changed nothing legally. But it meant something else. Something older. I wasn't just a name on a document anymore. I was the executor. And that word executor, it wasn't just legal. It was personal. I executed his final wishes. I executed the legacy they tried to rewrite. And I did it without yelling, without threats, without ever raising my voice. Just facts, just clauses, just leverage. You'd be amazed what power a single comma can hold. Meanwhile, back at the firm where Graham worked, rumors were spreading. Someone had leaked an internal memo suggesting a possible ethics review tied to his involvement in the will. Not from me. I didn't have to leak anything. That's the beauty of exposure. Once you pull one thread, the entire image starts to unspool on its own. He took a sudden personal leave. I sent him a fruit basket. Inside, one pear, one apple. One envelope with a sticky note that said, "Pair your compromise proposal. I found this more tasteful." No signature, just initials. Fee, C. I knew it was petty. But sometimes pettiness is just the poetry of justice. 3 cousins, 2 lies, 1 stupid mistake. That's all it took. You'd think after watching Madeline crumble in court and Graham sink under the weight of his own arrogance, the others would have stayed quiet. But no, my cousins decided it was their moment to rise. Enter Dean Tyler and sweet clueless Haley. Dean and Tyler were brothers' sons of my father's younger sister, who had passed away years ago. They always fancied themselves the forgotten heirs, the real backbone of the family name, even though neither of them could spell fiduciary without assistance. Haley was the baby cousin, kind, soft-spoken, and always just a bit too trusting. So when they filed a joint petition claiming an undocumented verbal amendment to the estate that my father had promised them shares in the family firm over dinner one summer, I nearly laughed. Instead, I requested a continuance. Then, I ordered a certified copy of the summer home's surveillance system log. Because here's what they forgot. My father was old school and paranoid. Every property he owned had cameras. Not for protection, for posterity. That dinner they referred to. I had the footage. I watched it on mute first. My father sitting at the head of the table sipping his whiskey. Haley talking. Tyler checking his phone. Dean pouring wine like he was auditioning to be a sommelier. And then I flipped on the audio. My father voice firm. No, Dean. The firm's not yours. It's not a sandbox. It's a legal machine. Vivian understands that. You don't, Dean. But we're family. Dad. Exactly. Which is why I'm telling you this now, so you don't embarrass yourself later. Ooh, that went into the evidence file. But I wasn't done. Tyler had submitted a signed statement affirming this alleged verbal agreement. I had a handwriting analyst compare it to other documents. Result: forged. And here's the kicker: he forged Dean's signature. Dean didn't even know. I called a private meeting, all 3 cousins. No lawyers. Just them, me, and a single manila folder. I sat at the head of the table. I didn't ask them how they were. Didn't offer drinks. Before we move forward, I said I want to give you a choice. I slid the folder forward. Inside. The surveillance footage. The audio transcript. The forgery report. Haley opened it. Her face paled before she even reached the second page. Dean leaned over to read. Tyler leaned back like a man in free fall. I let the silence sit. 1 minute. Then 2. You can withdraw your petition now, I said. Or I file a motion for sanctions and fraud, and you each lose your standing for the remainder of probate proceedings. Possibly beyond, Dean muttered. This is ridiculous. Is it? I asked, tilting my head. Because I'm holding proof. And what do you have? A badly faked signature and a bruised ego. Haley whispered, I didn't know they were lying. I believe you, I said gently. Which is why I suggest you leave them behind on this one. She did. 24 hours later, the petition was withdrawn. The damage, though, already done, because the court doesn't forget attempted fraud, even failed ones. Dean and Tyler were barred from any future claims involving discretionary assets. Haley, for her honesty, was left a symbolic stake, a portion of my father's antique coin collection, something he once told me he wanted her to have anyway. That night, I poured another glass of wine and stared at the ceiling. 3 cousins, 2 lies, and 1 little recording that proved once again. People talk too much when they think the smart one's not listening. Every family has a dark corner. Ours was Uncle Charles, big man, bigger mouth, loud at dinner, louder at funerals. He was the kind of relative who wore cufflinks to Sunday brunch and believed yelling was a form of affection. He also fancied himself the patriarch after Dad passed. claimed to have helped my father build everything, though his biggest contribution to the firm was once accidentally forwarding an internal memo to a client. After the cousins folded, I thought maybe Charles would stay quiet. He hadn't appeared in court in weeks. I assumed he was hiding, or planning. It was the latter, because one morning I opened my email to find a scanned letterhead titled, "Petition to Reallocate Estate Control, on grounds of executor conflict of interest," filed by Charles B. Calder. He was accusing me, the executor, of operating with malicious bias, manipulating the process for personal gain, and undermining family legacy. A Hail Mary. A dumb one. He claimed I had coerced my father into drafting the earlier will, that I had exploited his declining health, that the voice on the audio might not be authentic. Big words for a man who still used a Yahoo email account. I didn't reply. I filed. Counter motion. Straightforward. Brutal. Legally lethal. Inside it, verified medical records showing Dad was mentally competent up until 2 weeks before his death. A signed psychological evaluation by a third-party neurologist. A log of our recorded estate planning sessions complete with time-stamped signatures and cloud-stored video. Oh, and a copy of the NDA Uncle Charles signed 3 years ago when he tried to borrow from Dad's trust and was denied. Guess who the denial email was CC'd to? Me. At the next hearing, I didn't bring theatrics. I brought silence. I let Charles speak. Rant, really. Vivian has always been cold, unloving. She didn't even visit her father in his final days. To which the judge calmly asked Mr. Calder, "Are you aware of the notarized travel log confirming her presence for 3 weeks during Mr. Calder's final month?" Silence. "And do you deny," the judge continued, "that you attempted to leverage your position for a personal loan from the estate in the amount of $250,000 and were denied in writing?" Charles shifted in his seat, loudly. Look, families have disagreements." The judge raised a hand. "This isn't a family disagreement, Mr. Calder. This is probate law, and you're confusing emotion with entitlement." Motion denied. In fact, not just denied, rebuked. The court labeled his petition an act of obstruction and bad faith. Legal slap in the face. But I didn't gloat. I didn't so much as smirk. I looked at Charles as he gathered his papers, eyes twitching, hands unsteady. I remembered being 7 years old and watching him berate my mother in front of guests. I remembered him chuckling when Graham accidentally spilled juice on my debate trophies. I remembered a dozen tiny humiliations he never knew I carried. And I watched him lose, in silence. That night, I did something strange. I played that old recording of my father again, just to hear his voice. He said, "Vivian knows how to move pieces, but more importantly, she knows when not to move." I finally understood what he meant. Control doesn't always mean striking first. Sometimes control is letting your enemies set themselves on fire, while you hold the extinguisher and choose not to use it. And for Uncle Charles, I let it all burn. By this point, I didn't have to speak loudly. The court had heard enough. The family had said too much. And the documents, they spoke louder than any of us. But the real shift happened not in court, not in confrontation. It happened in the silence between hearings, in the whispers I wasn't meant to hear. Like when I overheard Haley at the courthouse cafe whisper to her mother, "Vivian's not like us. She knows what she's doing." Or when Graham's paralegal accidentally copied me on an internal firm email titled "Damage Control." Vivian Calder situation. Even the court clerk, who never cracked a smile, gave me a subtle nod one morning as I passed. That's when I realized this wasn't just about one will anymore. This was legacy lawfare, and I was winning. Let's talk about the weapon nobody expected. The executor's discretionary power. See, the executor of an estate isn't just a paper pusher. If the will allows it, and ours did, the executor can make independent decisions regarding how and when assets are distributed. Most families assume it's a formality. Not mine. Not anymore. The judge reaffirmed it in our 9th hearing. Given the clear intent of the decedent and lack of contestable counterproof, the executor misses. Calder may proceed with discretionary asset execution. It sounded clinical. It was nuclear. Translation. I could start reallocating property, settling claims, writing checks or not writing checks. And the first thing I chose to do? freeze the family firm's budget for board stipends, which meant no more cushy monthly payouts for Charles Madeline or anyone else on the so-called Family Advisory Council. Cue the emails, cue the voicemails, cue the desperate late-night texts that said things like, "Can we just talk? Let's fix this before it gets worse. Dad wouldn't have wanted this. Oh, wouldn't he? Funny. Dad didn't say that when they excluded me from the trust amendment group chat. Meanwhile, I made a few quiet calls. First to a real estate broker who specialized in legacy transition selling properties with complicated emotional histories. Then to a PR consultant, not for damage control, for optics. I was going to relaunch the Calder name, not as a nostalgic legal relic from the South, but as a modern woman-led estate strategy firm, built by me, rooted in the very law they used to keep me out. The name, Calder and Daughters. Because sometimes the pettiness is the point. I trademarked it the same week Madeline emailed, asking if I'd be willing to let her manage Dad's old cabin property. I replied with a PDF attachment of the deed transfer. Her name wasn't on it. The email subject line, as per Article 14, Section B declined. No body text. Just that. Did it sting? Maybe. Did I care? Not really. Because in that moment I saw clearly what this was. Not a feud. Not revenge. A rebalancing. They had tried to build a structure without its foundation. And now the foundation was in charge. I wasn't angry. I was in position. And when you're in position, you don't need volume. You need clarity. You need patience. You need the power to sign. And they'd just handed me the pen. There's something intoxicating about sitting quietly in a room full of people who once dismissed you while holding every single one of their futures in your hands. That's exactly where I found myself. It was the final estate reconciliation meeting. Not in a courtroom this time, but in a polished conference room with a long walnut table, legal pads stacked like coasters, and name placards that looked oddly formal for people I used to watch argue over Monopoly. Everyone showed Graham trying too hard to look casual in his blazer and jeans. Madeline in pearls, probably thinking the necklace would soften me. Uncle Charles wearing that smug face he thought passed for diplomacy. Even Haley came, though she sat toward the back, quiet and blinking like she still wasn't sure what she was doing there. And me. I wore black, not for mourning, for clarity, for power, for the visual of it. The meeting opened with legal formality. My attorney read aloud a list of confirmed distributions under the revalidated version B of the will. Item by item, the illusions crumbled. The house, assigned to the trust with me as trustee. The beach property, reabsorbed by the holding company. The family firm, in my name with all previous board stipends discontinued. The antique car collection, sold with proceeds allocated to a scholarship fund established in my father's name. They didn't interrupt. Not yet. But when it came to the final asset, the family's lakefront cabin, Madeline snapped. "This is insane," she said. "He loved that place. We all did. You can't just—" I didn't raise my voice. I didn't— "He did," I replied, and I held up the audio. The last clip. It was Dad speaking softly, nearly a whisper. "Let her take it all if she must. She's the only one who knows what it cost me to build it." Silence. You could hear Graham swallow. I didn't push. I didn't glare. I simply passed around a final packet. Inside, a signed deed transferring the lakefront property into the Calder and Daughters development portfolio, a breakdown of liquidation returns, a non-disclosure agreement. "Sign," I said, "and you receive your remainder distributions. Decline, and we go back to court." They all signed, one by one. Not because they believed in it. Not because they accepted me. Because they had no leverage left. Afterward, as they trickled out, heads low, footsteps slow, Haley stayed behind. She approached the window and stared out at the city skyline, lips pressed together. "You didn't have to destroy them," she said quietly. "I didn't," I answered. "I let them destroy themselves." She nodded. "So what now?" I shrugged. "Now I build a beat past." She turned. "Do I still get those coins?" I smiled, small but real. "You do." That night, I returned to my apartment, sat down on the floor, and poured a drink I'd been saving. A single malt scotch my father kept locked in a drawer with a tag that read, "Not yet." I figured this was finally the yet. I raised my glass. To legacies, I whispered, and to never being the one they expect. The glass was heavy. The silence was clean. I didn't feel victorious. I felt finished. Because there's a difference between revenge and restoration. And this was restoration executed legally, surgically, and absolutely. It's funny what people remember you for. For years, I was the quiet one. The one who left the family firm to pursue boring estate law. The one who sat in the corner at reunions drinking iced tea and reading legal briefs instead of gossiping over barbecue. But now I was the one they warned each other about. The woman who didn't yell, didn't flinch, just executed the paperwork and walked away with everything. After the final meeting, I started getting invitations. Suddenly, everyone wanted to reconnect. Graham's assistant emailed me about a possible strategic partnership between his new boutique firm and Calder and Daughters. Madeline sent a polite text asking if I'd be open to brunch. Charles, God bless him, even left a voicemail saying he was happy to move past the drama. I didn't respond, not out of spite, just because I didn't need to. The game was over. The court closed the estate that month, marking it settled without further dispute. I received formal recognition as full trustee and primary executor, with judicial commendation for clarity, diligence, and execution. I printed that part, framed it, hung it in my office just beneath a photo of my father and me at 16 in braces, holding a copy of Black's Law Dictionary like it was a novel. Calder and Daughters opened officially that summer. We started small, just 3 staff and 2 clients. But word spread fast. Turns out there's a demand for lawyers who don't flinch. My first big client, a widow whose brother-in-law had been skimming from her late husband's trust fund. She brought me a box of receipts, a tired smile, and a quiet plea. I just want what was meant for me. I got her every cent. When the check cleared, she brought me a pie and said, "You remind me of someone who doesn't raise her voice because she doesn't have to." I laughed. That's the idea. But there was one final thing left unfinished. The cemetery. I hadn't visited the grave. Not once. Not because I was angry, because I wasn't ready. But on a rainy Tuesday with the ink barely dry on my last court filing, I put on a black coat and walked through rows of stone until I found his name. David Calder, beloved father, relentless builder. There was no mention of family. Just those 2 lines, simple, sharp, like him. I stood there for a long time. Then I whispered, "You were right about all of them." And then softer. But I was right about me. I reached into my pocket, pulled out a copy of the final will version B, his real wishes, and tucked it under the flower vase. Sealed in plastic. Let anyone who visits know the truth. Not for them. For him. And for me. Because in the end, I didn't just execute a will. I executed a correction. You'd think that would be the end of it. The will was settled. The assets distributed. The family, what was left of it, scattered like brittle leaves. But peace doesn't arrive in a press release. It shows up in the after, in the emails that don't come, in the way no one calls to argue, in the silence that finally sounds like peace instead of punishment. I moved offices. Left the high-rise downtown and bought a modest brownstone near the edge of the city. Quiet ivy crawling up the stone and enough space for a private practice on the ground floor. The plaque outside. Calder and Daughters Estate Law Trust Management Legacy Advisory. No receptionist. No security guard. Just a buzzer that rang directly to my desk. Because now I chose who walked through my doors. It was during one of those quiet days sorting old documents and reviewing quarterly statements that I found a letter. Tucked behind an envelope marked personal effects. Vivian was a handwritten note. No date. No salutation. Just a few lines in my father's sharp, ink-heavy script. If you're reading this, you outlasted the noise. I knew you would. You were always the one paying attention. I didn't cry. But I did sit down, folded the note carefully, slipped it into the drawer where I kept the only things that mattered. His watch, my law school diploma, and a gold pen, with his initials engraved in tiny serif font. Some stories don't end in fireworks. They end in authority. Authority you don't scream about. Authority you earn. Quietly. Permanently. A few weeks later, I got a letter. Not an email. Not a text, but a real letter from Madeline. It was 3 sentences long. You were right. I didn't see it until the end, but I do now. No apology, just acknowledgement. And honestly, that was enough. We didn't become sisters again. We didn't go back to braiding hair or baking cookies. But we didn't need to. Some debts don't need repayment, just recognition. And I'd already collected the only thing I ever truly wanted, the truth restored. So I kept going, one client at a time, one legacy at a time, one quiet correction after another, until the day someone looked at my card and said, "You're Vivian Calder." That Vivian Calder. And I smiled slow and even and said, "Yes, I'm the executor." Success doesn't make a sound when it arrives. It doesn't knock on your door with fanfare or send confetti through your inbox. It sits down beside you while you work, leans in without a word, and watches you keep going. I had built something real, not flashy, not oversized, just solid. A law firm that didn't sell illusions. A reputation that didn't rely on charm, just proof. I'd grown my client base mostly referrals from people who'd heard I could handle the kinds of cases that turned stomachs and split families. Widows, disinherited children, betrayed business partners, quiet sons who had been written out for being too soft, daughters who were too sharp. They all sat across from me with the same hollow stare and the same trembling question. Is it too late? And I'd give them the same answer I had given myself silently over and over during my own war. It's only too late if you don't have receipts. They smiled when I said that, or at least they stopped holding their breath. It's amazing how powerful a spreadsheet can feel when someone's finally on your side. Meanwhile, the Calder name, once just a hushed monogram on letterhead, was gaining weight again. But this time it was mine. No board meetings, no golf course alliances. No cigars and brandy around a table of men who never thought I was worth the air. Just impact. Clean, traceable, undeniable impact. And with it came invitations. A university asked me to lecture on estate strategy and fiduciary ethics. A legal podcast wanted to feature my modern executor story. A publisher offered a book deal working title, The Quiet Power of Paperwork. I declined the last one. I wasn't interested in being famous. I was interested in being permanent, but even permanence has its costs. There were nights I missed the idea of a family, of someone saying, "You've done enough, Viv. Sit down." But I knew better. No one says that to women like me, to daughters who refuse to disappear, to lawyers who walk into rooms and make everyone suddenly remember their clauses. So I said it to myself. At the end of a long day when the inbox was clear and the firm lights turned off, I'd pour a quiet drink, look out the window of my brownstone and whisper, "You did it. You were the executor, and no one rewrote you." Then I'd breathe, just once, deeply, and the silence that followed. That was the sound of everything finally being in the right hands. There's a moment somewhere between justice and peace where you realize you've stopped surviving and started living. For me, that moment came not in a courtroom, not in a contract, but in the middle of a slow Tuesday afternoon. I was standing in line at the post office. Behind me, an elderly woman with a lavender coat and a stack of envelopes sighed loudly. She muttered something about bureaucracy and how nothing makes sense anymore. I turned and said, "Do you need help sorting those?" She blinked at me surprised. "You're too young to know how this works." I smiled. "I'm an estate lawyer. I sort complicated paperwork for a living." Her shoulders relaxed. "Then maybe you can explain why I need 12 forms just to get my late husband's account closed." I stayed with her. 10 minutes. Explained what she needed, how to sign what to request. She walked out a little straighter, and I walked out knowing, this is it. The real legacy, not revenge, not the property, not even the power. It was being someone who knows how to help when the world feels rigged against you. I used to think justice meant fire, drama, impact. But justice isn't always a gavel or a verdict. Sometimes it's helping a stranger untangle a form, or walking past the family beach house without flinching, or getting a text from Madeline that just says, "Mom would have been proud of you." I see it now. Sometimes justice is gentle, silent, settled. And speaking of settling, Calder and Daughters had grown. We'd opened a second office, hired 2 junior partners. One of them, a woman named Anna, reminded me of myself 10 years ago. Sharp, quiet, always watching. She came into my office one afternoon and asked, "How did you know you'd win that case? The one with your family?" I leaned back, thought about it, then said, "I didn't. I just knew they'd never read the fine print." She laughed. But I wasn't joking. Because people always underestimate the power of details, of boring, meticulous, relentless clarity. And in the end, that's what saved me. That's what changed everything. One clause, one form, one decision at a time. I didn't need a spotlight, just a desk, a pen, and a promise to never let anyone rewrite me out again. The silence now feels different. Not empty, just earned. I used to fear it. The stillness after battle, the quiet after court, the moment when no one's calling, no one's contesting, and your inbox holds only newsletters and client reminders. But now I sit in it like an old chair, familiar, steady, mine. I've executed over 40 estates since my father's, some simple, some ugly, but none as personal. None where the ink bled into bloodlines. None where every signature felt like a scalpel. I've built a reputation, a firm, a name. But more than that, I reclaimed something. Not just property or assets, not even legacy. I reclaimed myself. For a long time, I thought my family cutting me out of the will was the worst betrayal I'd ever experience. But now, I see it was the greatest gift. Because it forced me to build, it made me sharpen, it made me ready. They didn't just forget who I was. They never really knew. Not the quiet little girl who memorized legal codes before she wore lipstick. Not the woman who learned to listen harder than she spoke. Not the executor who would one day sit at the head of the table they tried to keep her from. And now, when I walk into a courtroom, calm, composed, understated people lean in. They whisper my name. Not because I'm loud. Not because I demand attention. But because when I speak, things move. And when I sign, things change. So here's my final clause. No footnotes, no conditions, no amendments. You don't need to scream to take back what's yours. You just need the truth, time, and the confidence to let silence finish what fire cannot. My name is Vivian Calder. I was cut out of the will, so I became the lawyer who executed it. And now, I execute everything. Sometimes the loudest justice is the kind you never have to announce. Vivian Calder didn't seek vengeance with rage or spectacle. She didn't scream in court or beg her family to love her the way she once did as a child. She simply executed, line by line, clause by clause. What began as heartbreak became clarity. What felt like erasure became power. And what was meant to exclude her became the very framework she used to reshape her family's legacy on her terms. She didn't just win, she restored. She didn't just punish, she protected. And in the process, she built something that would outlast every cruel whisper and every greedy hand that tried to silence her. Because Vivian Calder understood what most people don't. It's not about revenge, it's about control. And control isn't loud, it's quiet, professional, precise. She didn't fight for approval, she fought for truth. And in the end, she walked away, not only with the firm, the estate, and the legacy, but with peace. The kind of peace that only comes when the dust settles and the people who tried to erase you finally see who's left standing. Not by accident, not by inheritance, but by execution. End of script. Good night.